Okay, we are live.
Good morning, this is Senate Judiciary, the 25th of January. Just a little housekeeping announcements. Senate leadership decided to change the numbers of people that are allowed in committee rooms to a different number. I believe it's 18 in here. But people will not be allowed to stand behind committee members or the staff. So with 18, we'll try to accommodate as many as we can, but we may require masks if it gets overly crowded, and I hope people don't. You still have a Zoom opportunity, so I think people should be able to. Yes.
I just, 18 makes me a little uncomfortable, so if we get to that point, is it okay for me to step out and join by Zoom?
Yep.
Okay, thank you.
But speak to Senator Burr
Okay.
first. It's okay with me, but he's the one. This is about complaints from
I know.
various media. All right. With that, we'll take up S4, which is an act related to violence and other things. Our first witness is Chris Bradley from the Vermont Federation of Sportsmen.
Good morning.
Good morning.
For the record, my name is Chris Bradley, and I'm the President and Executive Director of the Vermont Federation of Sportsmen's Clubs. If you are not aware, the VTFSC has existed in Vermont since 1875. We were formed to help reestablish white-tailed deer in Vermont after they were hunted to near extinction. And we helped establish what is today known as the Vermont Fish and Wildlife Department. Our organization represents the sporting interests of approximately 50 member clubs in Vermont and there are approximately 14,000 members. Thank you for inviting the Federation to speak on this board. I'll be as brief as possible, and I'm happy to field any questions you may have about my testimony or the Federation. Regarding Section 1, prosecuting juveniles as adults, we fully support this section. Section 2 and 3, prohibiting premises from supporting various crimes, including drugs. These two sections do not directly relate to our interests. However, we fully embrace and support the intent. Sections 4 and 5, the duplication of federal law and state statute. As you know, currently federal law covers both the illegal activity of defacing serial numbers as well as straw purchases, both of which should be prosecuted. We did listen to the sheriff, wanted the flexibility to charge an offender under similar state laws, but there is a whole slew of federal laws that will remain with no state parallel. We make the following observations. Currently, both of these offenses are covered by federal law and as such have been or should be prosecuted by the federal government. We are not aware that the feds have been lax in their prosecution of these crimes in Vermont, but if they are not aggressively prosecuting, then we should contract our Congress people to have them address that. Having our law enforcement prosecute these cases is an added burden and cost to Vermont law enforcement, Vermont courts, and Vermont prisons, and therefore Vermont taxpayers, when this is now all fed. Under Vermont federal law, we believe we understand that these offenses are punishable for up to 10 years and or $15,000, while Vermont's versions would be up to 5 years and or $100,000. In the case of straw purchases, I just wish to make clear there is another federal crime that will have been broken, and that is making false statements on a federal form, which we believe can be charged by the feds as an additional offense. Section 6, prohibiting firearms from specific persons. Page 7, line 16 is worded as has been charged with. We believe that this may run afoul of Bruin. The reason for that is on September 19, 2022, in U.S. versus Quiroz, a federal law barring those under indictment from purchasing a firearm was ruled unconstitutional. We are also concerned about the definition of fugitive from justice, page 8, line 78. We assume that would mean out of state, and are non-violent crimes included in that? If a person is an innocent witness in someone else's criminal case, but they avoid showing up in court, do they become prohibited? Section 7, 9, 10, and 11, we have no issues with these sections. Section 8, prohibiting possession of semi-automatic assault weapons by persons under 21. A brief review is necessary. In 1939, case of U.S. v. Miller, the Supreme Court of the United States, SCOTUS, ruled that firearms, quote, in common use at the time, end quote, are protected by the Second Amendment. In the 2008 case of D.C. versus Heller, SCOTUS ruled that a law-abiding citizen had a right to have an operable firearm in their house. Their decision struck down the D.C. ban that required firearms be disassembled and or locked up as being unconstitutional, and stated, quote, the Second Amendment protects an individual right to possess a firearm unconnected with service in the militia and to use that firearm for traditional lawful purposes, such as self-defense in the home. This ruling, however, only applied to federal enclaves, which was D.C. In the 2010 case of McDonald versus Chicago, SCOTUS ruled that an outright prohibition on possessing a handgun was unconstitutional and stated that the, quote, Second Amendment right is fully applicable to the states, end quote. It further stated that the constitutional right to bear arms in public for self-defense is not, quote, a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. In the 21 case of Catano versus Massachusetts, SCOTUS ruled that the carrying of a stun gun was allowed by the Second Amendment and stated, quote, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. In the 22 case of New York State Rifle Pistol v. Berlin, SCOTUS ruled that law-abiding citizens had a right to bear arms outside of the home. In making that ruling, it stated that, quote, the exercise of other constitutional rights does not require individuals to demonstrate to government officers some special need. The Second Amendment right to carry arms in public for self-defense is no different. Beyond just ruling on the case, SCOTUS went further and set a new standard by which all Second Amendment cases must be judged. Gone are the days when courts could determine for themselves whether they should apply strict scrutiny, intermediate scrutiny, or rational basis standards or means to end tests. SCOTUS stated, quote, under Heller, when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And to justify a firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation. I'm not a lawyer, nor do I pretend to be. It is my understanding, however, that if a regulation pertains to a specific type of firearm, and that firearm is, quote, in common use, end quote, the Second Amendment presumptively covers ownership and possession of that firearm as being constitutional with no further testing required. All other existing or proposed regulations and laws concerning firearms, the burden is on the government to show that the regulation or law aligns with the text, history, and tradition of our nation's firearm regulation, which is being referred to as historical analog. As a nation, we have now been given a very clear and concise manner with which firearms laws can now be judged, and this new interpretation has and will impact a large number of courts and a number of existing laws, as well as new laws being proposed as our courts react. Section 8 of S4 is the nexus of two issues regarding firearms: a prohibition of those under 21 from possessing a wide range of firearms, and an assault weapons ban. Concerning the age 21 prohibition, On August 25th, 2022, the District Court of Texas ruled in Firearms Policy Coalition v. McGraw that a prohibition on carrying a handgun by those under 21 was struck down as unconstitutional under Bruin. Other cases are pending, such as Young v. Hawaii in the Ninth Circuit. In fact, just 2 days ago, the Eastern District Court of Tennessee ruled on Beeler v. Law, which struck down a prohibition on 18 to 21-year-olds from carrying handguns, a prohibition based on age alone. In regards to the other questions as to whether there were historical prohibitions on the age of a person to possess a firearm, such laws did not exist at the time of the founding. And based on that, age prohibitions on firearms, especially for those 18 and older, are unconstitutional. Concerning an assault weapons ban, we set aside any detailed discussions of the numerous problems and issues found in the various definitions of assault rifles, assault pistols, or assault shotguns as being moot, since the basic premise, i.e. an assault weapons ban of what is contemplated is not constitutional, and our courts are making this clear. Assault weapons have been and are being, assault weapons bans have been and are being struck down as unconstitutional, as these firearms are arguably in, quote, common use for lawful purposes by law-abiding citizens. Simply put, Section 8 of S4 does not and will not pass constitutional muster, and this is not just the Federation, the Gun Owners of Vermont, Traditions Coalition, or even the NRA saying this. It is SCOTUS saying this, with numerous courts following their lead, such as the District Court of Southern California in Rena versus Bonta Vaquera and Miller v. Bonta, the District of Southern New York, Lane v. James, Fourth Circuit Court, Bianchi Dominic et al. V. Frosch, and the District Court of Colorado, Rocky Mountain Gun Owners v. Superior, to name a few we are aware of. More are bubbling up literally every week. This is not a matter of, quote, let's pass it and see what the courts say. Courts have already spoken, more will be speaking in the coming months, such that it appears futile to us to attempt to argue that firearms like the AR-15, which we understand is the prominent firearm at the core of what Section 8 of S4 looks to address, are not in common use. They are in common use, with tens of millions being sold to law-abiding citizens after going through a background check. With a lengthy read, I encourage you all to read the Benitez decision in Miller v. Bonta, which provides an exceptionally expansive analysis on the text, history, and tradition as it applies to the AR-15 and similar firearms. I quote from the introduction to the initial decision rendered in that case, 94-page decision, rendered by Judge Benitez. Quote, like the Swiss Army knife, the popular AR-15 is a perfect combination of home defense weapon and homeland defense weapon. Good for both home and battle, the AR-15 is a kind of versatile gun that lie at the intersection of the kinds of firearms protected under DC v. Heller and United States v. Miller. Yet, the state of California makes it a crime to have an AR-15 type rifle. Therefore, this court declares the California statutes to be unconstitutional. Having shared that quote, I wish to share a balancing quote, and this is from the Heller decision. Quote, like most rights, the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. For example, concealed carry weapon prohibitions have been upheld under the amendment and state analogs. The court's opinion should not be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons or the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of firearms. Miller's holding that the sorts of weapons protected are those, quote, in common use at the time, finds support in the historical tradition of prohibiting the carrying of dangerous and unusual weapons, end quote. We heard Legislative Counsel Eric Fitzpatrick caution the committee about the Bruin decision. We heard Defender General Valerio also provide caution, and we heard his offer to provide a person from his office that will speak in depth to what I am addressing now. Ladies and gentlemen, Section 8 of S4 needs to be pulled and dropped, or pulled and split out into its own bill so as to allow the other meaningful provisions of S4 to pass. Within the next few months and across the coming year, the ramifications of the Bruin decision will continue to be resolved, which we are confident will only further underscore the unconstitutionality of Section 8. Based on the information we have, we believe that Judge Benitez will reissue his rulings on the California assault weapons ban by this next month, February, and we know he will not be changing his mind in light of Bruin. If Benitez's decision is appealed, which will likely be the case, it will go back to the Ninth Circuit, where a 3-judge panel already upheld Benitez's decision 2-1, with a 1 dissenting judge rendering his decision based on the past precedents of the Ninth Circuit, which were flawed as they did not comport to Bruin. If the Ninth upholds, the assault weapons ban will cease in California. If the Ninth strikes it down, there will be an emergency appeal to SCOTUS, and we are confident that SCOTUS will follow Benitez's crystal clear logic. Accompanying this testimony is research that I've conducted regarding Second Amendment cases, both historic and present. We believe it shows where our courts are going in the Bruin decision. We do not profess it to be complete, but are confident in what we have found and are now sharing. This shows firearm-related laws that have been or are in the process of being struck down. It's more powerful if you look at this document online, because I include links. I start with the U.S. v. Miller decision. I touch on Heller and McDonald, the Catano decision, then Bruin, and then all of the numerous cases. In red is what is being challenged, and green is what the decision was. And these are literally bubbling up, one just 2 days ago on the age 21.
Thank you.
As Senate Judiciary moves forward, as well as House Judiciary, the Federation offers its expertise and knowledge to help all concerned find paths forward that can help solve and address violent crime, while fully aligning the Second Amendment's focus on the unalienable right to keep and bear arms. I'm now done, sir. Yes, sir, please, hit me.
First of all, next Friday, we're scheduling the Bruin decision.
That would be Rebecca from the Defender General.
No, it's Professor Darrell Miller from the Duke Firearm Law Center, who's written a number of books about the Second Amendment. He's going to come Friday the 3rd.
The name again, I'm sorry?
Darrell Miller,
Joe Rule.
Duke Firearm, he's a co-director of the Duke Firearms Law Center.
We will hear from her and how this decision, she believes the decision impacts the various laws. My understanding is current law, I saw something on the news that now the manufacturers are making an AR-15 light that's marketed to kids.
JR-15.
JR-15, thank you. So I just caution that before we go down this road of, I'm someone who always had an A+ from the NRA until this election cycle when I dropped to a C because, which is fine. Any group's allowed to give me whatever ranking they want. But I've always tried to support the Federation and some of its stands, but times are changing, I tell you. It isn't. It's every day there's another mass shooting. And it's really alarming to have, in my opinion, the United States Supreme Court going backwards. But I do have a question on Section 6. I want to make sure I'm clear on your position. You're opposed to line 16 has been charged with carrying a dangerous weapon while committing a felony, trafficking regulated drugs, or human trafficking. Not necessarily being, you mentioned something about fugitive from justice, but you didn't mention that you're not opposed to line 12.2 or line 12.14.
No,
Just want to make it clear.
On the page again, I'm sorry, sir.
Page 7, you noted the objection to a fugitive from justice, which is on line 11. On line 16, you noted an objection to has been charged with, and that's carrying a dangerous weapon while committing a felony, trafficking a regulated drug, and human trafficking.
Hmm.
But you're not opposed to 2 and 3. That's what I'm trying to understand.
Two specifically, a final relief, that was already, that statute specifically says the court may order anything necessary to protect the victim and their children. That seems very clear to us that in that particular case, because due process has been applied, the defendant was had to stay in court. No objection from us. As far as the fugitive from justice, I believe I understand, especially from the Bennington discussions, that we have people coming in from out of state and then leaving.
Not only that, but we have a young girl who was in the custody of DCF, who ended up running away with a 37-year-old man, ended up finding him in Baltimore. And the question was, which state has jurisdiction? And the only nexus is that she was in DCF Vermont custody. He's from New York. But these things, drug cases in my area, they run the gamut. There's people, from Massachusetts and New York live, work, and are in all 3 states all the time.
Well, certainly, when laws are broken, we have consequences, or we should have fairly severe consequences.
This was just mirroring the federal laws of fugitive from justice, which is also illegal. Senator Brooks.
I thank Chris. We had a long discussion about the same issue yesterday, and undeniable that the Supreme Court is attempting very openly to alter the discussion permanently around firearms. I will say, to pick up on what the chair mentioned, that we're living in a world where mass shootings have gone from every month to every day, pretty much. So we're experiencing last year between 600 and 700 mass shootings. Now, when you were talking about you were quoting from a decision where a judge said that the AR-15 was the perfect weapon for battle or for home. And that strikes me as insanity. In other words, to dissolve the difference between battle and home, war zone and well-regulated civil peaceful society. And I think that's where people's indignation comes in, is that the court is attempting to move us to a situation where no state authority will have the ability to say to people, you can't openly carry semi-automatic weapons on the street. And I feel that that's where they're very quickly moving us. And I'll give you a chance in just a sec. So if I look at my own duty as a lawmaker, yes, the field of precedent has changed and the likelihood of prevailing in court has changed. I don't view my responsibility as any different, which is to prevent people from being killed by these weapons and to try my best to return our society to a place where we're moving away from the open carry, display, and use of weapons in everyday life. So now it used to be that people were afraid to go to school. Now they're afraid to go to bars, dance clubs, churches, all of the places that are now associated with mass shootings. And I feel as though the Supreme Court has made it clear that they're going to inhibit any effort to change that state of affairs. So to your point about the section on under 21 possession of semi-automatics, I think you're right. The bill would move more quickly and more easily through our building if that were removed. It would also have an easier time in the courts. But I do believe that I at least feel a responsibility to continue to push on the availability of semi-automatic weapons, the use display of those weapons in everyday life. So I may vote in any given case to advance something up the court system to challenge where the Supreme Court is going. And I feel like that's all that's left to me, given that the Supreme Court has authority that trickles down to us. But I take your point, and I think your point is logical in the sense that the Supreme Court has made it the logic that we have available to us, but it is an insane logic. And I'll just be honest about that. I feel like we should be moving at all levels of our government to reduce the amount of guns in our country because we clearly can't handle them as we're currently constituted.
You respond?
Yeah.
A lot to unpack there, Senator. Yeah. And to just take a step back, I do not intend to be argumentative. However, the interpretation of the Second Amendment has been flawed for years and years and years. It is now only now being seen as other rights have been seen all along. When we talk about violence, we understand we don't support violence. We don't support armed insurrection or any such thing. It's not law-abiding citizens that's causing this. And the vast majority of firearms owners are arguably law-abiding citizens. In response to your open carry comment, one of the things when the hospital bill came up, it was our view that it was what you could see that was upsetting people, not what you couldn't see. So I absolutely agree. It is simply not done from the people that I know to walk into a hospital openly carrying. It's simple propriety doesn't do that. Most hunters don't walk around with, or most Second Amendment people don't walk around with guns on their showing because we know that it is disturbing to people. I have to argue in the final analysis, why is Vermont continually a safe state when we have such a high proliferation of firearms in homes owned by competent citizens who know how to safely handle them? And the fact of the matter is, you can conceal carry. As far as open carry goes, the Supreme Court's addressed that. If a state were to say you can't open carry, you cannot prohibit concealed carry, and vice versa. So I have to argue that, and I've had this quote before, Robert Heinlein, an armed society is a polite society. Manners are good when one has to defend their acts for their life. And that may sound a little bit over the top, but quite frankly, as we look, citizens themselves have a right to self-defense. And that does not stop when you go into a bar or a tavern. It doesn't stop when you get on the subway. Yes, there are certainly sensitive places, and I understand that. And we're not trying to be radical here. Violence is pervasive. Drugs, mental health, people just going off the rails. Against that, and we see it every day, there's a significant amount, and I just published an op-ed on this, of defensive uses of guns that never get reported. And it often doesn't even involve firing the gun or doing anything more than saying, I have a gun. When we consider what an equalizer is between a criminal who is planning something bad or one of these mass shootings, it's just not in our rationality even thinking about that. We don't. But self-defense is an unalienable right. And as across the years, individual courts have made individual decisions as to how to look at that means and balancing. Gee, is the strict scrutiny or intermediate scrutiny? It's a constitutional right. We now have a very clear guidance from the highest court of our land as to how it should be interpreted. And we can suggest that it's insane. I respectfully disagree. This Constitution has stood the test of time for hundreds of years. And the fact that we've been looking at this one aspect, perhaps incorrectly, is now coming to the fore. Honest and law-abiding citizens have a right to defense. That right is in the home. That right is outside the home. And yes, sensitive places, absolutely. It's an unalienable right, but I regret to say, over time, there's no question it's been reversed. And now we're doing a correction.
I first want to just say that I want to be careful about characterizing people with mental health issues as violent. People with mental health issues are far more likely to have violence perpetrated against them than they are to be violent. In
I
fact,
believe I made that.
no, you
correlation.
did.
I
Your
didn't
statement.
mention mental health as an issue, yes.
Okay, well, I just want to clear that up.
Thank you.
I also would like to ask a question about section 8, and is it in your view that a grenade launcher is in common use by law-abiding citizens?
Absolutely not.
Thank you.
However, grenade launchers can be legally owned in the state of Vermont.
I understand, well, this is trying to change that for at least people under 21, so I just wanted to get your
Oh,
clarity on whether or not that was something in common use.
Grenade launchers, no, or can't.
I mean, I would agree, but I just wanted to be clear.
No, thank you.
And then the other piece in section 5 that I just love, or section 8, not 5, that I'd love some expansion on, and is the piece around the manufactured weight of a pistol that is 50 ounces or more. Are there many pistols that are less than 50 ounces?
The majority of them are.
Okay,
Any other?
no, that's it.
Okay, thank you. Any other questions for Mr. Bradley? Thank you very much, Chris.
Yes, thank you for listening to me. I appreciate it.
Our next witness is Will Moore, who's firearms policy analyst for the Vermont Traditions Coalition. Will is visiting us from somewhere in the kingdom.
Am I on completely for sound, and is the sound quality good?
Completely on.
Very good. Can everyone hear me well?
You're fine.
Very good. Well, I'm in Johnson, Vermont, and some up here would resent if I refer to that as the kingdom. So I will defer to the local tradition that it doesn't start till you get to Hardwick.
Well,
How are you?
I'm fine.
Excellent. It's good to see you. I understand that some people I was with over the weekend have a flu. And so, erring on the side of caution, I chose to stay home this morning.
I compliment you on that and thank you for doing that.
No problem. My pleasure. Senators, some of you I know, some of you I don't. For those of you who haven't met me, my name is William Moore. I've been in and out as a volunteer advocate and also a paid researcher in the State House since 1988. Most notably, recently with the Vermont Traditions Coalition. As a volunteer advocate, I am their firearms policy analyst. As Senator Sears indicated, I live in Johnson, grew up down in South Burlington, and I'm a graduate of Johnson State College. So another state college product in front of you this morning. I am attempting, as I told Peggy and Senator Sears earlier, excuse me, I'm attempting to not fairly repeat Chris Bradley's testimony, but I want to add that we agree in toto with his written testimony. So on top of that, I'd like to add some layers. I'd like to nuance some points, but I will not repeat the whole thing. Also wanted to make sure that folks, do understand that this is a deep, dark, legal, complicated subject area that Chris has attempted to valiantly explain. Supreme Court precedent as it's evolved, and I believe now at its apex on Second Amendment issues, is now being applied in various and sundry efforts across the appellate court region, and with mixed results. The court will act when necessary and allow the appellate courts to read their own decisions and act accordingly when they do that correctly. So, having said that, in the course of history of this, for instance, of the First Amendment, I should note, you all have an email in your box right now with my written testimony. As a matter of fact, Peggy has it. She'll post it accordingly.
Did not receive anything from you, Bill.
Peggy?
She said she didn't receive anything, Bill.
Checking it here. Yay. I'm sorry, Peggy, you're the only one I left off. Is that an awful thing? Please excuse me for that. I was so busy trying to make sure I got all the senators in that I left you off, and I apologize. So now on to my written document. I want to preface this by saying that, again, because I'm not attempting to repeat, I'm trying to add some perspective to where we are. And I wanted to sort of reiterate the flux of Supreme Court decisions, but I want to add a historical pretext. In First Amendment precedent, what we all understand to be the First Amendment was not expressed in Supreme Court precedent until the early 1920s, and even as late as the 1960s, where some of you may be familiar with cases involving the New York Times and so on. As that evolved over decades, literally, many of us and many folks like you sitting in state houses were caught off guard as their laws either became unconstitutional or they were drafting laws that literally in real time were being declared unconstitutional that they had thought were constitutional a week ago or 10 days ago or 10 years ago. We are in about the 14th or 15th year since Heller of that evolutionary cycle. None of you should be faulted for not understanding the depth of this. I certainly don't profess to. I don't think Eric can honestly have the time to be a full-time Second Amendment scholar. So on that note, I will move on to my written testimony. Pardon me. Excuse me. Item 1, the current status and express system of Supreme Court of the United States, decisions and precedent directing this text, history, and tradition by use of historical analogs test for any and all infringements on the Second Amendment rights precludes many elements of bills now being considered by the 23-24 biennium of the legislature of the state of Vermont. Quote, Bruin approvingly quoted Heller that constitutional rights are enshrined with the scope they were understood to have when the people adopted them, and noted that Heller looked at mid to late 19th century evidence only as mere confirmation of what the court thought had already been established. That paper is not a news article. This is a journal review article from the Harvard Law and Policy Project. He's making the point that it would be an error for this body and for courts in the appellate region. Pardon me, I'm having a tickle. Excuse me. It would be an error for legislatures and courts in the appellate region, much less the state Supreme Court of Vermont, to anticipate that recent case law, particularly in the post-Civil War era, could express the original intent of the Second Amendment, with regards to restrictions. And I think Kate, probably Chris made the point, or at least in his citations, it's clear that we wouldn't certainly want to stand on the precedent of Jim Crow laws in the Reconstruction period, even though at the same time there were some other analog laws to what you're proposing that were race neutral. So the court was making a specific statement here that era is only relevant as it confirms the colonial era and the revolutionary era and the constitutional era as the underlying understanding of what the Second Amendment meant. On that note, I think that age-related discriminations are really, they just don't hold up over time. We should have one age for the right, one age for the age of consent, and be done with it. I'll get to that a little bit here, and then I should move pretty quickly. As such and accordingly, we oppose and ask deletion from the bill as follows, including sections 1, 7, and 8 of S4 as restrictions based on arbitrary age stratifications or otherwise lawful possession, and the irrational and unlawful exposure of otherwise protected juvenile, criminal, or family court records and investigations by any state agency such as DCF and law enforcement generally, to treat constitutionally enumerated, unalienable pre-existent rights as we would civil privileges like operating an automobile is offensive to the other enumerated rights such as habeas corpus and the right to a legal defense and a speedy trial. Item 2, would anyone like to ask any questions on that first section before I move on?
Well, I just am surprised that you'd want to protect people carrying dangerous weapons while committing a felony.
Well, it's the age-related section parts of that concern me. So maybe it's a matter of reworking it. And I
just am surprised that we're protecting people that are committing a felony with a dangerous weapon.
Well, it's more of a question.
I didn't see that as too controversial.
Well, I wouldn't say it's one of my priorities, but what I would be concerned with is that juvenile and family court records, such as are being addressed here, have been treated a certain way up to this point. And I think it's probably important to have a much broader discussion about any changes and how those are sealed or unsealed or utilized in further.
Because we're all welcome to our opinions, Bill. I'm just surprised that you're opposed to that.
Just concerned about the constitutionality of it. That's all. But yeah, it's not necessarily in line with a lot of my usual concerns. I agree with you there. Any other questions on that first section?
Just to clarify, so are you saying that it's constitutional for someone to carry a firearm in the commission of a felony?
No.
Okay.
I'm concerned with 14 or 15-year-olds being automatically, because it requires that proceedings against 14 to 21 years originate in criminal division. I'm concerned that they're being tossed into that system, sort of along the lines of our now failed drug war.
I'll only point out that and it's likely that the vast majority would be treated as youthful offenders and not as adults. My guess is that.
So am I misreading what's here, which says require?
No, it starts in the adult, in the superior court, but it would probably be treated in most cases as a youthful offender.
Well, that's reassuring. I'm glad to hear that.
By the prosecutor, depending. I mean, even some of the more alarming cases have been treated as youthful offenders.
Right.
So it's part of this bill to look at those particular crimes, which are recent. A number of out-of-state kids have come to Vermont who are juveniles, have committed felonies, mainly drug trafficking and human trafficking. And that's the main focus. And the idea here is that they usually end up back in their home state, but getting them from here to there is an issue. So But I would guess we've left open the door for youthful offender status, which would be in the family court. So
Fair enough. I
I was
appreciate that.
alarmed as maybe at first read of it is knowing that my guess, even some of the high profile cases get dealt with as youthful offender.
Yeah. Well, I'm certainly in favor of it insofar as it addresses gang activity and drug traffickers. I'm only concerned that people who could otherwise be treated for addiction and low-level drug selling not get trapped in the
Well,
same.
we're all concerned about that.
Very good. Thank you. I appreciate that.
That people receive the treatment they need and that treatment is available. I only point out Bennington, we don't even have a methadone clinic that's available to my constituents in the county. They have to go to, since Rutland, Vermont or Brattleboro, Vermont.
Well, I'm sorry to hear that, Dick. We have,
But treatment
fortunate
is
here
not
in
available at this
Yeah.
point.
we're fortunate here in Lamoille County. We have both Teen Challenge and Jenna's Promise in addition to the state-run facilities, the recovery center and so on. So I hope that you are able to address that in Bennington
Well,
County.
we're trying to, and I, my hope is that part of introducing this bill and hopefully successfully passing it will result in more options in smaller communities.
Yeah. Anything we can address the related gun crime.
Anyway, I'm taking you off your,
That's okay. It's always fun. So I will move to item 2 if there's no other questions. Items of proposed legislation and related infringements listed here, such as bans on firearms and related self-defense weapons, so-called dangerous weapons, including non-lethal items like sprays and electronic devices, bear spray and taser type devices, age-related discriminatory infringements and device restrictions, i.e. magazine bans based on capacity, are all unconstitutional prima facie following the Catano and Bruins decisions built upon Heller and McDonald. These cases cited below and elsewhere in Mr. Bradley's testimony as well. As such, all such legislation should include budget appropriations of between $100,000 and $350,000 in anticipation of the inevitable legal challenges forthcoming after passage. I would propose a standing estimate for such legal process to be prepared for the Joint Fiscal Office to be attached as evidence here and where similar legal challenges are likely. Referral to the Senate Appropriations Committee is here formally requested for the purpose of evaluating budgetary impacts on the long list of injuries and usurpations likely to be the result of the passage of S4 and other bills, I should add. Recent ongoing lower and Supreme Court actions regarding the magazine ban statute should provide an excellent fiscal cautionary tale for JFO to provide good guidance for the Senate. It's an aside. It's related to the larger picture of other legislation that's also in the room. So it's not necessarily a big jab at this bill, but I had to put that in as part of the position of the Vermont Traditions Coalition. Any questions on that? Very good. And a final statement. As a nation, our legal system and citizenship are encased in a robust form of faith. We exercise faith in each other while we drive the road, expecting others to submit to the rules of the road. We trust our children to the dangers of car travel every day based on this faith. In criminal law, we also expect and exercise faith in others to support us in our pursuit of living a free and virtuous life as we do the same. That we will not be accosted, abused, cheated, or otherwise subject to assault by either the powers of the state or our fellow citizens. Excuse me. In fact of history and law, all our civil laws and constitutional protections are based in faith that our fellow citizens agree to these social compacts and expect the same from us. When these traditions and the faith that underpins the moral virtue we expect and understand to be our birthright break down, crime, violence, and other abuses are the result. We obviously are living in that unfortunate condition in some areas of the state of Vermont. Destroying and infringing upon the ability for citizens to defend life, liberty, family, and the pursuit of a virtuous moral community will not replace these underlying and essential moral equations. Our Vermont constitutional founders expected as such and repeatedly inserted these understandings in the formation of our frame of government and our enumerated rights. The founders of both the Vermont state and United States constitutions took robust and proud notice of our history and traditions in the British common laws, the philosophical underpinnings of the Enlightenment, and its connected foundations to Judeo-Christian ethical and communitarian expectations. It was that very foundation, abused and usurped by a rogue British king, that led to our revolutionary stance and Declaration of Independence, after attempting in the Parliament and the courts to regain our freedoms. Vermont's Constitution contains many elements that reflect these expectations and speak them eloquently. Many are familiar with regards recent school and marriage cases. Some are sadly all too unfamiliar and bear rebirth and repetition. I offer below, and also now will read into the record, Chapter 1, Article 18, regard to fundamental principles and virtues necessary to preserve liberty. That frequent recurrence to fundamental principles and a firm adherence to justice, moderation, temperance, industry, and frugality are absolutely necessary to preserve the blessings of liberty and keep government free. The people ought, therefore, to pay particular attention to these points in the choice of officers and representatives, and have a right in a legal way to exact a due and constant regard to them from their legislators and magistrates in making and executing such laws as are necessary for the good government of the state. I submit today that infringements upon the rights and privileges of Vermont's lawful gun owners is a feel-good false confidence that ignores the true issues plaguing our children, such as drugs, depression and mental illness, gang activity, human trafficking, and more. To ignore the clear and present danger of the depraved, immoral, and indecent nature of our present madness across this great nation, reducing the prescription to more restrictions on freedoms whilst ignoring the deplorable conditions our society finds itself in, we invite disaster and misery for ourselves and generations to follow. I further assert that a renewed recurrence to fundamental principles and a firm adherence to justice, moderation, temperance, industry, and frugality are absolutely necessary to preserve the blessings of liberty, and if taught early and often to ourselves and our children at every turn, is a better way out of this present madness. Senators addressing better schools, stronger families, healthy kids, and robust religious institutions to support these should be applauded, and these kinds of restrictive and useless laws should be rejected. Chart a new course here today and reject the false economy of infringement and usurpations. Love your children, love liberty, hug your family, and seek faith in our ability to overcome today's malaise. Thank you for your efforts and attentions here today. And thank you for any questions you may have.
Are there any questions for Bill? Bill, thank you very much.
Appreciate the time. Hope to see you live soon.
I hope so.
Be well.
Our next witness is Eric Davis, President of Gun Owners of Vermont. Eric is joining us remotely.
Hey, good morning, Senators. Can everybody hear me okay?
Yep.
Yep, good morning. So, as Senator Sears mentioned, my name is Eric Davis, and I'm the president of Gun Owners of Vermont. We are an all-volunteer nonprofit advocacy group dedicated to the preservation of the right to keep and bear arms. And I'd like to thank the committee for having us here today to give testimony on Bill S4. I'll begin by stating the obvious, that this is a lengthy and multi-layered proposal which covers several different areas of law, and my testimony today will focus mainly on sections 6 and 8, which deal directly with the possessions of firearms. Before we get into specifics, I'd like to acknowledge the situation at the nexus of this bill, with the violent crime occurring in Bennington and other areas of the state. Indeed, I wasn't aware until we heard from the folks in Bennington last week that the events in that area had escalated so severely. We certainly sympathize with the community, and we appreciate the efforts of the senators in drafting this bill as a measure to help reduce that violence. However, we also believe that any legislative steps to help protect the good people of Vermont should be considered very carefully and with great respect to the rights of those same good people. The parts of this bill which deal with gun prohibitions are slightly different in their approach. Section 6 prohibits possession based on a set of behavioral criteria, while Section 8 does so based on a combination of age limits and physical description of the firearms in question. And I'd like to start with Section 6. In this section, the bill seeks to ban possession of firearms for fugitives from justice, persons subject to a final relief from abuse order, and persons subject to a no stalking order. It also seeks prohibition for those who have been charged with but not yet convicted of carrying a dangerous weapon while committing felony, drug trafficking, and human trafficking. Now, here at GoVT, we sometimes take a lot of heat for our no compromise approach to gun legislation. And that's an approach which we believe is rooted not only in the constitutionality of the right to keep and bear arms, but also the moral premise that every person has not only a right to self-defense, but also the right to access the means with which to defend oneself. That said, the premise of a moral right to self-defense should be understood within the paradigm of non-aggression. Defending oneself is not an aggressive act, nor is the act of obtaining the means with which to do so. And I say all this as a segue to my point that if one is to be stripped of their inherent natural rights, it should be considered in the context of whether or not that person has violated the same pact of non-aggression against their fellow man. It appears that Section 6 at least attempts to do this. We understand that not everyone out there should possess a firearm. We get that. There are certain folks in our society who should probably not have a gun. So we're not disputing that. And it's hard to argue that someone who has committed a crime from the list of transgressions laid out in Section 6 shouldn't make the list of prohibited persons. So, there's some fairly serious stuff on there: drug trafficking, human trafficking, et cetera. Those are very serious infractions. So it's hard to argue that they shouldn't make a list of prohibited persons, at least temporarily anyway. In some cases, maybe these legal issues get resolved and they can get them back. I don't know. That's more of an area for the judiciary. But our concern with this methodology lies primarily in the realm of due process, specifically the language that those who have not yet had their day in court might be stripped of their rights, and worse, than an innocent person might possibly remain prohibited after having been acquitted of the charges. Judging by the recent rulings from the Supreme Court in different states, which you heard Bill Moore and Chris Bradley speak of, one could reasonably speculate that the courts would also find this methodology flawed, especially when considered in the context handed down in the Bruin decision. So Section 6 appears to be on the right track in the sense that it considers prohibition based on aggressive and violent behaviors. However, we'd be more inclined to support it, if the wording was a little bit different, with a little more careful in specific respect to due process. That's where the majority of our concern lies with that section there. Moving on to Section 8, then this is where we find the majority of our issues with this bill, and everybody, probably saw that coming. But Section 8 entirely disregards individual behavior altogether and seeks to impose a sweeping ban on firearms based purely on the arbitrary criteria of age limits and physical characteristics of certain firearms. And it's obvious that this wording is someone's best attempt to give legal description to the popular yet contentious AR-15 style rifles, which have gained a lot of notoriety lately among proponents of gun control and gun rights activists alike. It's also obvious to anyone with a basic understanding of the mechanical workings of firearms that this description was written by someone who does not share that same basic mechanical knowledge of firearms. And without launching into an hours-long discussion and multi-page lecture here, dissecting each and every one of the highly flawed descriptions which attempt to assign a legal definition to this popular misnomer of assault weapon, I'm just going to try to couch our objections to this approach in the most concise and rational terms possible here. Approaching this discussion from the angle that restrictions on age and or certain types of firearms as an effective hedge against the violent behavior of a few bad apples is objectively flawed. Not only practically, but both morally and constitutionally as well. From a practical standpoint, this type of blanket ban will have very little, if not zero, effect on the ability of violent and/or youthful offenders to obtain such a weapon for nefarious purposes. When legislative action is taken to restrict access to firearms in an attempt to keep them out of the hands of criminals, it always affects the law abiding to a far greater extent than the bad actors at which it's purportedly aimed. When violent and organized criminals know the laws and know that our judicial system is either incapable of or unwilling to enforce those laws, they will continue to behave badly, and we've already heard testimony to that effect. A good person who doesn't want to break the law, or in this case, the person who purchases a firearm through the proper legal avenues of going to an FFL and completing a background check, will be the one denied their constitutional rights, while the criminals will continue to utilize straw purchases and stolen weapons to further their ends. And once again, regardless of the intent of such legislation, this approach generally only affects the people that you don't have to worry about. This ties back to our previous discussion about the morality of banning guns based on arbitrary criteria rather than targeting specific individuals and their actions. I can't imagine a rational justification for a young person to be criminalized based on the actions of people that they have never met from places that they have never been. And I like to imagine a scenario where maybe your teenage son is responsibly enjoying an outdoor activity like hunting or target shooting, whereupon he might be arrested or worse and cited to appear in criminal court for the simple misfortune of being stumbled upon by a game warden or other law enforcement officer while committing some ridiculous infraction, such as having a rifle with an adjustable stock or a threaded barrel. Once again, it's our position that it's objectively wrong to criminalize anyone based on something they might do, or worse, something that somebody else might do. And finally, from a constitutional perspective, it seems that the laws which restrict both age of ownership and certain types of firearms are well on their way to being ruled unconstitutional once and for all, with courts across the country issuing judgments against such legislation, which you heard Chris and Bill focus on extensively, so I won't go into great detail about that. So as should be obvious by now, we strongly and vociferously oppose the restrictions proposed in Section 8 of this bill, and we hope that the legislature will discontinue their efforts to restrict gun ownership in this manner. And I'd like to close by stating that gun owners are very conscious of how every incident involving improper use of a firearm reflects poorly on gun culture of a whole. We are very, very, very conscious of this, and we do not like seeing this violence as much as anybody else does. It's absolutely terrible. And whether it's a drug and gang related activity or an instance of negligence where someone's harmed due to the unsafe handling of a weapon, we understand that it's a black mark on our long-standing traditions of safety and sportsmanship and deterrence of aggression. However, we also know that gun ownership in itself is not an aggressive act and should never be treated as such. We believe that pursuing such measures will take what has the potential to be a good bill in S4 and turn it into a bad bill, which will harm law-abiding citizens. We appreciate the efforts of the legislature to curb the violence in our communities, but we hope to see that accomplished with more focus on consequences for individual actions of malice rather than punishing good people going forward.
Thank you, Eric. Senator Baruth has a question.
Certainly.
Thank you, Eric. I appreciate it, especially your final remarks. In listening, I was struck by how often you reference morality, but always from the perspective that morality should be ensuring that more weapons are in the hands of more people. And I think that's the crux of the dispute. Other people looking at this would say morality dictates that everyone attempt by whatever means possible to prevent their fellow citizens from being killed. With that said, I'm wondering about age restrictions. It seems to me that you called it your no compromise stance, which you said you take heat for in your organization. On age limitations, if your stance is no compromise, do you support the constitutional rights of, say, an 8-year-old or a 10-year-old to possess and use a semi-automatic weapon?
Well, Senator, when considered in a constitutional setting, I think that's certainly a discussion to be had. But if I could speak philosophically to that a little bit,
Well, if I would appreciate a yes or a no answer on it.
Oh, okay, certainly. So I think from a constitutional perspective, there needs to be some sort of consensus on when somebody is an adult and when, those constitutional rights are, when you are, when you become an adult and when you are entitled to those constitutional rights. I mean, there's been some Supreme Court cases, which have ruled in the realm of due process, for instance, that the juvenile is entitled to the same due process as an adult. Philosophically, I'd like to speak to that, I was shooting firearms and semi-automatic firearms at 8 years old. So, I obviously didn't own one of my own and carry it to school or anything crazy like that. However, I think the conversation should be centered more around responsibility for one's actions. And as Bill touched on a little bit, as a society coming back to a place where we value life and value our fellow humans more and respect each other, and that sort of thing. So I don't know exactly.
If I could just tease out what you're saying. So you said we should develop a consensus.
Well, I think
one way to develop a consensus is to have a legislature move a bill and have the governor sign the bill, which we did in Vermont. And that was 21 years of age with some carve outs if you had a hunter safety course, et cetera. But you're arguing that we need a different means of consensus.
Well, everybody has a different opinion on what that is. So I guess I'm not sure, maybe I might have to backtrack a little bit on that if consensus is possible. But I guess for legal purposes, there should be some sort of definition of when adulthood starts, and when, rights are sacrosanct, if you will. And if, someone is not entitled to certain constitutional rights if they're under a certain age. I think that's a very hard discussion. And to be honest with you, the more I think about it, the more I think that's kind of a broad and fuzzy line. And it's very difficult to draw a sharp, something right across that to say, okay, if you're 16, you can do this and not have this right, but you can have this right over here. So I think that line is broad and blurry, and I guess up for discussion. So
Appreciate it. We do have an age of majority in almost every field of 18 or 21. But I take your general point. You don't like the sections that have age restrictions, and you don't like the semi-automatic section in its whole. So
Senator Wojcicki has a question.
I actually have a legal question, so I think it is more for you, and that is around the definition of possession versus ownership. Is there a legal distinction between those?
Yes.
Okay.
Yeah, absolutely.
So possession would be on my person, ownership would be physically mine and I bought it?
Right. Legal ownership is different than possession within your possession and control.
Okay, thank you.
Yeah.
Anything else, Mr. Davis?
No, senators. Thank you. I think that's it. I'd like to thank the committee for having us today and for your consideration.
Eric just wrapped up.
All set? Okay, Jessica, Sarah is next.
Good morning.
Good morning.
The record, Sarah Robinson. I'm the Deputy Director at the Vermont Network Against Domestic and Sexual Violence. And Wonderful to be here with you all, and I think this is my first time here this session, so good to be here. And thanks so much for the invitation to talk about S4. I'm going to do just a little bit of broad framing around our position on the bill. I'm going to speak specifically to Section 6, and then hand it over actually to my colleague Jessica Barquist to talk about the juvenile jurisdiction questions, which is really her area of expertise. But just broadly and big picture, we certainly take a lot of interest in addressing violent crime, especially as it relates to domestic violence, sexual violence, and human trafficking, which we know have significant impacts on victims of crime. And we know that when these crimes intersect with the use of firearms, the potential for harm is greater and needs to be addressed. So I'm going to start by just talking a little bit about Section 6 of the bill, which truly has been a long time policy priority for the network. And I'm speaking specifically around those lines 12 through 16. And I'm going to provide just a little bit of background information from our perspective around civil orders. They are essential and time-limited safety tools for survivors that provide conditions for safety mechanisms such as limitations on contact and distance restrictions. And these civil orders are particularly helpful for survivors who don't seek to immediately involve law enforcement or the criminal legal system in their case. Relief from abuse orders that are found in Title 15 and sexual assault and stalking orders, which are found in Title 12, are both used to seek protection from forms of abuse, including domestic violence, sexual violence, and stalking. Which one of these tools is used depends on the relationship between the parties. However, both orders do follow somewhat of a similar process in that an emergency order may be sought by a plaintiff and granted ex parte, then the court sets a hearing, and within 2 weeks, there's an opportunity for both parties to be heard. And after that hearing, the court may issue a final order for a specified period of time. So the language contemplated in the bill in front of you today applies to these final orders. While seeking a civil protection order is a really important safety tool for survivors, it also poses a significant risk. We know that there is a troubling relationship between domestic violence in particular and stalking behaviors and firearms. And we know that the presence of firearms in a violent home increases the risk of death for victims of domestic violence in particular.
Senator. Sarah, can I ask you a question about domestic assault and homicide in the state?
Yes.
Do you have the number or just a rough idea of how many domestic violence situations end up turning into homicide situations?
That I don't have an exact number for you, but what I can tell you is that of all homicides in the state of Vermont, approximately 50% of them are domestic violence related. And so that gives you a sense that domestic violence has an outsized role in the most serious of those crimes in our state.
Thank you.
Yep. We also know that the two leading risk factors for lethality risk factors for victims of domestic violence are the presence of firearms and leading. And just referencing your conversation earlier, there's also a really troubling connection between domestic violence and mass shootings. I actually submitted to the committee, it's on your web page, a study that indicates that approximately 2/3 of mass shootings in the United States are related to domestic violence. So if granted, we know that these civil protection orders are effective at keeping survivors safe over time. There was a meta-analysis of studies that were conducted on protection orders that indicated that they do lead to long-term reductions in police-reported violence. So federal law already creates certain categories of persons who are prohibited from firearms possession, including people subject to certain qualifying protection orders. And the language that you are contemplating in S4 crucially codifies that federal protection and ensures that all people who are subject to those final orders, both of those types of final orders, are considered prohibited persons under Vermont statute, which will allow for more effective enforcement of that. So that's kind of all I have to say about section 6. I'm happy to take any questions on that section or hand it off to my colleague.
Any questions? Thank you.
Okay, thank you
Good
so
to
much.
see you.
Thank you.
Yeah, you too.
Happy New Year. Jessica.
Hello. Thank you for the invitation to speak today. Jessica Barquist, I'm the Policy Director at the Vermont Network Against Domestic and Sexual Violence. And the Vermont Network, we are really deeply appreciative of the work that this committee has done over the years to expand juvenile justice and all of the reforms that have been made regarding raise the age and youthful offender. And we remain really committed to that overall purpose and direction of that work and believe that it is really beneficial for long-term community safety. Policy changes related to raise the age and youthful offender have helped to move our legal responses to criminal behavior among emerging adults and juveniles toward greater alignment with criminal justice reform efforts and the neurobiology of emerging adults. And we know from neuroscience that the brain is not fully developed until an individual reaches their 20s, and that this adolescent brain is highly responsive to risk-taking, peer influence, and reward systems. And we've also, in the past few years, really deepened our understanding of trauma on the lives of youth and the ways that responses to trauma can manifest as really harmful and even criminal behaviors. And we really believe at our heart that it is essential that youth who commit crimes have access to resources and interventions beyond punitive legal responses. So access to systems of accountability, supervision, and support help ensure that youth can grow and develop into full and productive members of our communities. Juveniles who are charged with domestic violence, sexual violence, or even human trafficking are most likely also victims of trauma, abuse, and violence themselves. And that being said, we also recognize that these crimes are really serious offenses. They are not victimless crimes, and they deeply impact community safety. So we believe that the goal and how our systems respond to these youth should first and foremost be to intervene with the intent to interrupt a trajectory and rehabilitate them so they can develop healthy relationship skills and live safe, productive lives within our communities. And while changes to our court procedures may assist in assuring that these cases proceed in a streamlined fashion, treatment and intervention must be a co-equal part of this approach. Adolescent and emerging adult brains are the most malleable and amenable to these interventions. This is a critical moment for intervention and treatment as it relates to our long-term reoffense outcomes. And yet, to date, there are insufficient treatment options as it relates to domestic and sexual violence. For example, we still have no youth-specific domestic violence accountability programming, which we commonly refer to as DVAP in our state. And youth are unable to participate within the adult domestic violence accountability program system as they should be. That's not an appropriate system for them, but there is no equivalent for our youth. DCF used an RFP process to develop a proposal for a youth pilot program, and a final report was issued by a team at Bennington College. And this proposal holds much promise, but it has still not been funded or initiated by the department yet. So it's important to note that even before the expansion of our Raise the Age and YO systems, there was a lack of resources and treatment available to support justice-involved youth. But policy was put into place with the hope and intention that treatment systems would expand to hold these youth. For a variety of reasons, those treatments and intervention services have not been expanded to meet the needs of this population. And this lack of investment in treatment and intervention is, in our opinion, the most pressing issue within our juvenile justice system. These intervention options need to be accessible to all youth who need them across the state, regardless of where they reside. And we were really excited to see the proposals for community grants within this bill. And we would ask the committee to consider how these funds could be used to prioritize that geographic equity in access to interventions. And then the other point I just want to make is that if the committee does decide to make changes to where youthful offender procedures are housed, such as the suggestion we heard to move YO proceedings from the family division to a sealed criminal proceeding, we would just advocate that there would be additional language added to ensure that the victims retain all the rights and access that were afforded to them last year upon the passage of S-224, which was Act 160. Domestic and sexual violence are intimately personal crimes, and victim involvement in those court proceedings is often really essential to the victim's healing and safety, as well as to the offender's learning and rehabilitation. So that is all I have, and I thank you for your consideration and just for all the efforts that this committee has done to advance policies to increase safety for victims of crime as well as our communities. And just noting that we're really committed to strong data-driven policy behind the expansion of our juvenile justice system, and really look forward to working with you to strengthen that system in ways that also enhance our community safety over the long term.
Thank you. Thank you for your testimony. I am wondering, given the absolute lack of treatment supports for youth, and I hear that there's this Bennington pilot, but if there are model programs elsewhere in the country specifically relating to rehabilitating youth from trafficking, gang activity, and substance use disorder.
Yeah, I can't speak to substance use or gang activity, but there are some model pilot programs that have been really successful in the domestic and sexual violence realm that we would love to see replicated here.
And anything around trafficking, I know I brought up the same concern that some of the trafficking language doesn't consider that most people who have been trafficked are in fact victims themselves, or are trafficking.
Yeah, I think that is a larger conversation for sure. And I'm not sure I have a really good answer for you in terms of like folks who have been charged with trafficking. But there are a number of interventions that our member programs and others in the state provide to support people who are victims of trafficking.
Okay. Yeah, I'm just trying to get a sense of how we learn from what's been successful in other places, and certainly have heard multiple points of testimony along the way that have been sort of grounded in punishment and retribution of youth who are engaged in these activities. When we, as you pointed to, we know that those youth are in all likelihood trauma survivors themselves, and in a space where their brains are malleable and they can be supported and rehabilitated and healed from the damage that they have done, while also taking accountability for the damage they have done. So I just wasn't sure if you had an awareness of other places that had those programs that we might be able to replicate.
Yeah, I'd be happy to do some research.
Thank you.
Yeah.
I think right now, but the trafficking that Bennington is seeing is not what I would consider traditional trafficking, which is people who are, massage parlors, for example, which we've seen around the state, who are being forced into sexual acts with people coming into those. What is being seen in Bennington is people who come up to sell drugs, get in a relationship with usually a woman, but sometimes men, and sometimes kids, who then provide those people with drugs, and then exert sexual usage, but also stay right in the apartment and won't leave, even when asked to leave. So it's not a traditional, and I'm not even, hopefully, we're using the right statute, but it's more of a kidnapping without kidnapping. They're still in their own apartment. They're not allowed to leave. I mean, I've read affidavits from some of these cases, and I've just, I'm not shocked as easily as I used to be. But I found some of it really alarming. What these, one particular one was a mother and her daughter, what the daughter was going through. She wasn't really being abused. but she was just in this situation that her mother wouldn't get her out of. So I'm hopeful that there's an understanding of what we're looking at. But we're also looking at people who are quickly gone and then replaced by someone else. And so for the community grants, the idea is to lower the demand and keep the community safer. And I would agree that the efforts we made to raise the age and et cetera can still go on through the youthful offender statute. Just as people with a big 12 can currently are under that same process. And I know the administration has about 29 proposed crimes that we'll look at, but these seem to be the two that were most prevalent, at least from the Bennington perspective, with an inability to deal with them. I also agree that the lack of a replacement for Woodside has become a challenge. And the only places for females is currently in Bennington at the Vermont School for Girls or whatever the name of it is. And then the depot programs, the retreat, and now the program in Brattleboro run by the sheriff. So you've got a very limited number of options, a few others around the state. But that needs to be part of whatever plan you do. There needs to be options, not necessarily for punishment, but to hold accountable and to be able to hopefully provide some form of rehabilitation for these youth. So I just want to make clear in developing this bill, it really looked at what other conditions, but I want to also, if you all have suggestions on the human trafficking portion of what I just described, if it's really different from.
Yeah. Well, I would say that what you described is pretty typical of what we see across the state, that human trafficking in Vermont isn't necessarily that stereotypical massage parlor, people coming in from other countries or other states kind of a scenario that you would think of when you hear human trafficking, but it is people who are, their substance misuse and abuse gets them into situations where they experience sexual coercion and violence and all of that within their own community. So our member programs are often responding to victims within our communities who would be considered victims of human trafficking in that way.
Do you have the availability of programs for these victims?
I'm gonna let Sarah answer that one.
Yeah, I know that you'll be hearing from several other trafficking organizations, and so I do want to let those organizations testify, but I would say that broadly, no, we do not have the infrastructure that is needed to provide services to victims of human trafficking in the state. And there have been several efforts to address this over the years, but I would say that particular response remains insufficient. And I think that is exactly why communities like Bennington and other communities struggle to figure out what the resources are that can respond to both the people that are causing harm and also the people that are stuck in those situations.
The police, the Bennington police are in the process of hiring somebody who's experienced human trafficking to help some of these victims.
Yeah, and to your point around treatment and the race, the age, I think that was exactly the point I was trying to make, is that regardless of how we charge these or where these crimes are, that treatment really needs to be first and foremost and front and center in how we're looking at these cases.
Any other questions? We have one more witness before we take a break. He is from Brattleboro. Vice Chair would like to introduce.
Yeah, this is Chris Lukasik, the victims advocate from the Windham County, and He's awesome. Yeah. Thank you for coming, Chris.
Thank you, Senator, and thank you, Mr. Chair, and the members of the Senate Judiciary Committee. My name is Christopher Lukasik. I am a resident of Brattleboro, and I'm joining remotely from Brattleboro. I've been working for the Windham County State's Attorney for about 6 years, but I have employment experience in working at a psychiatric hospital as well as substance use prevention. That said, I'm not here to testify on behalf of the Windham County State's Attorney nor the Department of State's Attorneys. I'm kind of just coming here as someone who understands victim services and understands juvenile justice reform. Most of my comments are going to be surrounding services for juveniles. So Raise the Age did shine a light on, but didn't cause programming or service availability problems for juveniles in Vermont. Program planning obviously takes time and money to ensure that those programs are useful for juveniles to engage in and rehabilitate themselves. Obviously, when we are in need of a program that is just a minor shift from what we have, that can be implemented pretty quickly. But you just heard from Jessica about juvenile domestic violence accountability. I want to inform the committee I'm leading the team that is developing that program right now. It's taken about 2 years to get from the idea to hopefully in the next month having a request for grant application through the Department for Children and Families. This is because there's a lack of practical and academic knowledge about domestic violence accountability for juveniles across the United States. Bennington College did a really good job of sourcing all that information, but again, it took time. So I just wanted to highlight as one area that while we don't have domestic violence accountability right now, it's been a very long process to build that type of program. Separately, the Big 12 list that we have in Title 33 is not reflective of all public safety needs in Vermont right now. It is a non-exhaustive list of offenses that doesn't reflect the whole picture of what violent crime looks like across the state. Obviously, the term public safety is difficult to explicitly define, but domestic violence, firearms, and drug use continue to be major public safety matters in Vermont that affect both adults and juveniles. Domestic violence offenses are not on the Big 12 list as an example of something that is not reflected in the Big 12 list. There are limited intensive and inpatient programs for juveniles in Vermont, especially those battling addiction or at risk of addiction. And the community grant program that is listed in Section 10 of this bill should be focused first on establishing those types of rehabilitative services across the state in order for juvenile court or whatever, wherever youthful offender may end up, can then refer juveniles to those types of programs. The only inpatient psychiatric beds for juveniles exists in Brattleboro, and we need those types of services to be established in more places across the state. There's not sufficient services available to ensure proper supervision for juveniles who are committing drug trafficking and firearm offenses. You heard from State's Attorney Marthage earlier this week about thoughts regarding dividing certain offenses up in family court and others in criminal court, and that not allowing for a whole person approach that the court process should have for juveniles. I definitely agree with that because it can cut the appropriate resolution options we have for juveniles. And additionally, speaking from my victim services brain, dividing those charges up into family court and criminal court can give pretty confusing and sometimes mixed messages to victims about the process that the court will provide and the possible outcomes that the process can give, even with the helpful guidance of a victim's advocate. I encourage this committee to ensure that you're considering victims in all of these processes, because after violent offenses are committed, victims need the information about what's happening and need to be able to freely communicate with victims advocates and prosecutors about what's going on. The changes to the victims' rights reflected in Act 160 last legislative season was significant process that needs to be reflected in any changes that occur to youthful offender or delinquency processes as this bill is discussed. So, in summary, allowing this $10 million fund in Section 10 of this bill to only be available to municipalities cuts the ability to build rehabilitative services through our designated mental health agencies, restorative justice agencies, hospitals and health practices, and state agencies. So allowing grant awards to be available to a wider array of organizations will allow for more robust programming rather than robust programming in regions rather than in specific locations, and will have the ability to fill the gaps in available services that can be provided to juveniles subject to delinquency and youthful offender petitions. That's what I got for you.
I agree with most of what you said. I will disagree and push back on the grants. The reason that it's developed the way it is to give those municipalities the opportunity. For example, if Bennington wanted to and saw it as their priority, making sure more rehabilitation was available, that's fine, and they could apply for the grant that way. It's designed to reduce the demand for the drugs. So obviously that would work, but maybe Rutland wants to go back to a project vision thing where it looks at particular neighborhoods and how it can help those neighborhoods. I've got neighborhoods in my district that are well known for the drug trade, et cetera, and those neighborhoods could use some help. And the folks that live there who are not involved at all would have a much better quality of life if the drug trade wasn't going on in their building, for example. So it's based upon a successful program in Massachusetts that went to state's attorneys, but I didn't want to send it to state's attorneys in Vermont. No offense to our state's attorneys in Windham or Bennington County or anywhere else, but we looked at options, and obviously the committee could change this, do what it wants, but the idea was what's unique to that community's need. And clearly that's something that they're best able to make their decisions on. And then the granting through the Department of Health, I think hopefully indicates that the goal is something to do with health and not necessarily tanks or, SWAT teams.
That makes a lot of sense, Mr. Chair. I was just saying maybe try to cast a wider net rather than just leaving it to those.
But I also think that we need to do a better job of funding treatment within both the local mental health centers as well as in more long-term residential care for substance abuse, particularly for kids who need more than 30 days. I mean, usually kids need 90, the minimum days. And yet insurance and other factors enter into it and don't provide that length. So I think we need to look at those as well. I appreciate your perspective and what you're doing down there in Windham County.
Yes. Thank you.
Continue, Chris.
Continue too.
Okay, we're going to take a break until 5 minutes of